Good morning, Ventura. Welcome to another fun-filled episode of Fun with HR, the show where we basically talk about human resources and try and sprinkle you in between.
Good morning, Rosandra.
Hey, Jeff, what's going on?
Oh, it's been a busy week.
Oh, you are not kidding.
I don't think I've ever heard the phones ring as much as they did this week.
I know.
And a lot of really strange stuff.
I know.
So you can't just like auto dial it or auto fill it in. I mean, we actually had to think and work this week.
Well, we do every week, let's be honest.
We do, but there's a lot of stuff that's pretty easy. This stuff really made us research and have to work hard. So
Yeah.
it was good.
And you know, I was really surprised how much HR was in the news. Did you hear that?
Yeah, I did. In fact, the first thing I want to talk to you about this morning, and Marie Davis, our labor attorney that's in the studio today, you could jump in anytime if we're going off the rails.
Sure, why
here,
not?
but Cracker Barrel evidently served a client cleaning solution in their water glass.
Wow.
It was inadvertent, but this happened 2 years ago in Tennessee, and a jury just awarded that customer $9.4 million.
Holy cow.
Nice, huh?
Huh.
I'd be willing to take a sip of cleaning fluid for $9.4 million.
That is not a challenge.
Yeah, that's not one of those TikTok
No,
challenges.
no.
Please do not do that at home.
That's insane.
It is insane, but the thing that I feel sorry for the customer about is you think you got $9.4 million, and it turns out Tennessee has a cap on damages of $750,000.
Ouch.
So I'm sure there's going to be more in
There
the
is a
courts
little
to
bit of a
hear.
difference between those two numbers.
There's a lot of zeros missing there.
Wow.
Yeah.
Wow. So there is that. And then this morning, I heard Starbucks in Santa Cruz is starting to, in essence, the union labor process. 22 out of their 37 employees voted to invite a union to come in. So we have our first Starbucks being unionized.
And that could be pretty interesting to see after one if they are successful in organizing, how many other Starbucks are going to follow.
Right. Right, because I know we do have friends and family that have worked at Starbucks, and some of the things they've said certainly make my hair stand up, but, you know, it is what it is.
Starbucks is franchise or all company owned? Do you know?
I don't know. You got me to say those words. Shame on you.
Uh-oh. Let's not let that happen too often.
But let's talk about what we do know, the ought to run.
We do know Fun with HR team is trailing the Ashley team in official registrants.
Yes.
We know we got a lot more. Spence,
I haven't officially registered. I'll do it immediately,
we
sir.
need you to do that.
Marie, we'd like to invite you to be part of our team.
Absolutely.
And what this means is, just so you all know, we want everyone to be part of our team because Ashley has said that if we beat the number of participants in her team, she will donate an additional $300 to the Autism Society. So it's a win-win. You win because you're going to obviously be part of our group and you can walk with us, or we win because Ashley gives more money. Either way, it's a win-win.
That sounds great.
It is a win-win. And like we said, even if you're on Ashley's team in previous years, for this year anyway, jump ship, join the Fun with HR team, because Autism Society ultimately
We'll
wins,
get more money, yeah.
which is the name of the game, right? That's
Absolutely.
the whole idea.
Absolutely.
So we will gladly contribute Ashley's additional $300 when we beat her team.
Right. And just so you know, everyone that has said to us, yes, we're going to be on your team, I have your names, I have your emails, and I will be sending you a link so that you can make it official.
And as a future attorney, Rosandra will let you know that your verbal agreement is a contract. So you are bound to follow through on that.
Right. But here's the other incentive, besides the wrath of Rosandra, right? The other incentive is starting in the month of February, we're going to randomly give away a manicure or pedicure to Frenchies. So if you're part of our team, you not only have to feel good, but you're going to look good. And we're going to help you do that.
Exactly. And if you're an early registrant, you have a better chance of winning that gift certificate because as names come on, we're going to add them in add them in. So
Right. So right now we have 3 people that have, because you and I don't count.
I wanted to count.
No,
Oh,
we can't count. We got to be, kind of like, the big guys and say if you work or play and blah, blah, blah. It
Okay.
doesn't. So you and I don't count.
okay.
But isn't that exciting?
It is exciting.
So one of the things that I want to do, because I know everybody is rushing to their internet browsers right now and trying to register. Hold on, we have a great show lined up for you. As promised, we are going to have Marie Davis, who you've already heard the voice. The myth, the legend is here. And one of the things that I want to make sure you all know is that we are very humbled and honored that she's taking the time on a Saturday to come out and help us. I am going to let you know that this is just a snippet of what Marie and her staff are going to be talking about in the yearly update. So we're going to let you know how to register for that and how to attend, because it's very important. Just so you know, from the HR standpoint, we go to no less than about 10 updates just at the beginning of the year, because everyone will give a little bit different and everybody will talk about their take on the laws. And as HR people, we just want to know who is out there, what is out there, and who we could actually speak to if we ever have a question. We have many attorneys, but none like Marie, in the sense she is, in fact, one of my go-to people. Why? Because she answers the phone.
And she's an enabler.
She is. So what?
She walks in today with tiaras, and anybody that
As it
knows
should be.
Rosandra that's her favorite thing.
As it should be. As it should be. I should be able to wear a tiara non-stop without people going, "Who's the crazy lady?"
I think you should.
Good answer.
Good answer. Yes. So Marie, just so you all know, is partner at Landegger, Verano, and Davis. Not only are they local, but she has lots of years of experience. Like I said, she is one of my go-to people. And the way we're going to work the show, just so you know, because I didn't want to bombard Marie with like, the sky is falling, but the sky is not falling as normal. Why do I say that? Because normally we're dealing with like thousands of new laws, and this year it was like 770. So I don't know what happened, but I'm not complaining, and I'm sure you're not, Marie. But what we're going to do is we're going to talk about some of those odd questions that we've gotten and kind of see what we can do to answer them. And then the second portion, we're going to go into 2022 new laws, and then we're just going to kind of see what comes out, because I think we're going to have a lot of questions that are either emailed, text, or what have you to us. So either way, Marie, welcome to the show.
Thank you, Rosandra. I'm happy to be here.
Thank you for bringing the tiaras, as every guest should know.
See, I think that's important. I want to make sure I know my clients and my friends, right? Plus, I think I'm going to wear these from now on during my depositions and my mediations, since everything is over Zoom.
Oh, I think you need to wear that into court.
Yeah, I need
Yeah,
to
good
do
luck.
a little something. I need
Good
a little
luck.
something extra.
I had Zoom DOL hearing last month, and I was really surprised when the hearing officer says, "Hello, Rosandra," and I thought, "Oh dear, they know me." And she says, "Yes, we've had a few cases together, and I want you to know I'm keeping track." And I thought, "Oh, they've seen me a little too many times." But it was really nice because the person didn't show up, so I didn't have to go through my normal, I like to call it my dog and pony show. Basically, I go through the beginning to the very end. So that was kind of nice. I don't think, I don't know if you walk into a courtroom if they're going to be that nice to you like that.
Well, like I said, I don't get to walk into courtrooms anymore, so, we'll see.
So let's talk about some of the questions we've had. One question that was had is, with everything happening, kids are going back to school, and I'm sure the fundraisers are coming. Can I take my kids' fundraiser stuff into work and ask my coworkers to participate?
Yes, you can, as long as you don't have a policy that prevents any type of solicitation whatsoever. If your policy says no solicitation of any kind, and you are you're a mid-level employee, you're not a supervisor, You're not a partner. You're not the boss. But if you're any other employee and they want to bring in their kids' cookie dough fundraisers and wrapping paper fundraisers, they can put it out on the table. They could send out a little email that says, if anybody wants the Girl Scout cookies or magazine subscriptions, wow, I'm really aging myself, right? Because none of that happens anymore. Then you are allowed to, please come to the break room and fill out a form. That's perfectly okay. As a supervisor or as a boss, I would not encourage that whatsoever, that behavior, because then you are making, you're kind of sending the message that this isn't really a choice because I'm your boss, and so you have to buy everything. But you're also allowed to have a strict policy of no solicitation of any kind. But if you don't have that policy, then I'm comfortable with it. And if somebody complains, then we have to deal with maybe it's not such a good idea, and next year we won't have it in our policy.
Now, you said you could email to everybody. You have these, and to go here or wherever to fill out a form to get them. Isn't that a misuse of company resources?
Only if it's in your policy, though. So if you are in fact allowed to, unless you've said we won't allow these types of emails or this type of solicitation of any kind. But if you don't have that policy, then it's fine. But you can also have two different kinds of policies where it says you are absolutely not allowed to have political messages sent on company time. You're not allowed to talk about, some sort of TV show or movie that's a little bit polarizing, anything like that. We're talking about kids' fundraisers. But it's really based on your policy.
So what you heard was policy.
Yeah.
Which means normally, where are these policies held? In a handbook, right?
Correct.
So if you don't have a handbook, can you just have random policies?
Yes. Even if you don't have a handbook, you're allowed to change the terms and conditions of employment at any time with or without notice. So when things come up like this, if somebody's actually offended because I'm offended by the fact that my coworker is selling wrapping paper and I don't like presents or whatever the reason is that they're offended, then you may have to change your policy. So a month later, you can issue an email, you can issue a written notice that says we no longer accept fundraising of any kind in the office.
Wow. So all it takes is one person and we need to change it, which we all knew about. One of the other questions that has come up is regarding bereavement. So unfortunately, during the first part of COVID, everybody knew that we weren't able to immediately bury people that have passed. And then also, it was taking some time. We know a few people that it took a couple of months to bury their loved ones. And so the question was, bereavement policy says you have 3 days, but do I have to take it on, basically close to when the person died, or can I take it months thereafter? And I thought, holy cow, only during COVID will we ever have the question of, can I take bereavement months after the person has passed away? Have you encountered this?
No, actually, that's very interesting. You're right. I mean, that's a very interesting question. But once again, let's start with, there is no law that requires you to provide bereavement leave. So that's number one. If you are a generous employer and you have offered that benefit to other employees, or if it's in your handbook, then you do have to abide by it. Clearly, when you did that policy, when you wrote that policy, it was probably prior to COVID, BC, right? In the BC times. So I would suggest that now that restrictions are lightening, I would not say that it was okay to take bereavement leave 4 months later. But again, it's whatever is in your policy. But if, like all these people are dying. Bob Saget was buried 1 week after he died, right? Mm-hmm. So the bereavement leave would be immediate. So I think you can absolutely tie it to when the burial occurs. But I'm not going to take bereavement leave 4 months after my father was buried. That's not really bereavement leave anymore. That's more of probably an anxiety or mental health.
Right. So we're at that point. I mean, they probably need more time than 3 days, 2 days, or even 1 day.
And it's not bereavement leave. It's more something else, probably like a medical condition or, yeah.
Yeah. Wow. See? This is why I love her. One of the things though that I've been asked about lately is also workers' comp. When is it appropriate to file a workers' comp and when is it not? And so, just so we're all very clear, if you're an employer within the state of California with employees, you have to have workers' comp insurance. And this is different from liability insurance. And I have to say it like this because every time I talk to a new employer, they always tell me, I'm covered, I got liability insurance. And I have to break it to them that workers' comp is different. So take us through, when is workers' comp appropriate?
And actually, this did just come up with me, for the client a couple of weeks ago. I got a text message from her saying, do I need workers' comp insurance? And I called her immediately. And I was about to go into a meeting, and I called her immediately, and I said, yes, you were supposed to have workers' comp insurance. Why did you never tell me you didn't have workers' comp insurance? And she said, well, I got all of the insurance I got from paychecks or whatever. And so I thought I had it. And then I just called them and they said I didn't. And I said, we're going to hang up this phone and you're going to get it today, like at first, because if you don't have workers' comp insurance, let me tell you, the fines and the penalties in California are outrageous. They could be like $10,000 a day, I think, if they do an investigation. That's number one. Number two, and this is the more important thing, if an uninsured worker actually gets injured, makes a claim, they're coming after you personally. So I have a lot of clients in that situation. I mean, I'm able to resolve the claim, but it's tens of thousands of dollars depending on the injury. And that's just for like a sliced finger. So if somebody really gets injured, we're looking at hundreds of thousands or millions of dollars. So first of all, it's the law. That should be the very first insurance you get. And it shocks me that anybody could open a business and not know that. Like, I feel like it should be part of the, I'm going to open a corporation, first page, make sure you have workers' comp insurance. Then I have clients that say, well, all I use is independent contractors. There's no such thing as independent contractors. You have to have workers' comp insurance. That's, the biggest issue. Second, you need it. Second question was, when do you use it? You use it when one of your employees gets hurt on the job. Now, that's BC, right? So and now where we are is we've got a lot of people working from home. Everybody thinks that's a great idea. You still need workers' comp insurance. What happens when I'm working from home?
And you trip.
Right. I slip and fall on my way to the bathroom. I slice my finger open when I'm cutting the bagel in the kitchen because I want to take a 10-minute break and have a bagel. I can, in fact, technically file a workers' comp claim because I'm on the clock. Third, what if I get coronavirus or COVID? Yes. So if I get COVID, I can also now file a workers' comp claim. Depending on if I got it at work and was exposed, they can make a claim. And that's a new thing that's happening right now. And I don't only practice workers' comp, so I don't know how that's playing out. But
the COVID claim, though, is you can't make a COVID claim if you're working remotely from home, though, right?
Correct. But if you're in the work site and there's an outbreak and all these new OSHA rules and regulations, you can.
Yeah, in the workworkplace.
So what about volunteers? Workers' comp and volunteers?
There's no such thing as volunteers.
Aha, thank you.
Well, okay. You had me worried.
No,
Okay.
No. I'm just leading you down the path.
Okay, so no such thing as independent contractors. No such thing as volunteers. Interns have to be tied, just briefly, to a school, and they have to earn school credit. Easter Bunny and Santa Claus are still real, though, everybody listening. So, but there's no such thing as independent
That's why
contractors.
she's your favorite attorney.
That's right. Wow.
Now let's back up a minute. Work comp, for people that made their workforce remotely, work comp, you need to notify your work comp carrier to make sure that's cool with your work comp carrier, though, right?
Absolutely. You should always be checking in with your broker about every 6 months because things are changing. And the other piece of insurance that we always highly recommend, it's expensive, but it's worth it in the end, is employment practices liability insurance, EPLI.
EPLI. We often tell our clients to do that.
We're going to hold that thought.
Okay.
We're going to take a break real quick. Okay. Fun with HR is brought to you by the HR firm. You can reach them at 805-853-3476, because if you have employees, you have issues.
The HR Firm is the premier human resource consulting firm in Ventura County, specializing in working with small to mid-sized companies. The HR Firm provides a complete suite of offerings to keep your company compliant. The world has changed so much in this last year, and so have all the rules for you as the employee. Are you ready? From handbooks to policies and procedures to workers' compensation claim management, the HR Firm is here to support you with all of your HR needs. They offer complimentary 1-hour consultation for you as a new client. Check them out on Facebook or Instagram or email them at info@thehrfirm.com. The HR Firm. If you have employees, you have issues.
This is Bob Davis, Ventura County resident for over 50 years. Loan Depot and I have teamed up to provide fax and mortgage lending experience that gives you satisfaction that you want to share with people you love. 805-658-7435. That's 805-658-7435. Real, honest, and fair mortgage lending. NMLS 249185.
Clean, modern, engaging. Frenchie's is not your typical nail salon. We're better, way better. You'll find a friendly staff, a fun vibe, posh pampering without steep prices, and a super clean, inviting space that gives you all the good feels. To experience this for yourself, call us at 805-200-3883 or email us at venturaca@frenchiesnails.com.
Hey employers, are you tired of spending your valuable time posting jobs on the job boards? Are you tired of looking through resumes to find that one diamond in the rough? Your time is way too valuable, so let the professionals at Atharva Workforce find that diamond in the rough for you. Spend more time on your business and less time looking for those employees. Call Atharva Workforce at 805-826-0033.
Welcome back to Fun with HR. Well, we're having a very spirited discussion
We
here, so
are.
continue.
Okay, well, where should we pick up?
That's like that's sounding a lot like when I say, Jeff, be romantic, go.
Oh, you didn't go there. Ouch.
Exactly. Well, we were talking about work comp and volunteers.
Yes.
There's no such thing as volunteers. Interns only if they're really tied to an actual process, meaning they're in school. What I wanted, and I love that you said that, Marie, because really, in essence, what the state of California wants to make sure is that if there's any work done, that the person gets properly compensated. What is the minimum wage that they should be compensated?
Oh boy, that
I'm
was a
good,
nice
huh?
transition. So yes, January 1st, employers in the state of California with more than 26 employees, minimum wage has gone up to $15 an hour. So it's finally happened. For employers with less than 25 employees or less, it's gone up to $14 an hour. And as you know, if you're in LA or Santa Monica or San Francisco, it's already up to like, I don't know, $29. No.
$17.75.
Yeah, it's up there though, $17.75 on its way up.
Well, that's why it was really odd for me when we come across these things. Jeff and I obviously nerd out over this, and he says, you know, there is such a thing at this point. Somebody is trying to introduce legislature to keep that minimum wage coming up. And I thought, holy cow, a lot of small businesses can't bear that, but yet they're going to be forced to. And so that was a big deal. And it's a big deal because there's another thing that most people don't realize, and that's the exempt status. Now, exempt or non-exempt is from overtime. And that's going to be something that we won't get into, but I'm sure Marie is able to talk a little bit more about in her update. Let's talk about what happens with those exempt people when there is a minimum wage hike.
Right, and just again, quickly to touch on what Rosandra was saying, there are two tests that you have to meet in order to be exempt. One is the duties test, which we don't have time to talk about today. And the other one is the salary test. Mm-hmm. What does that mean? So it means that you have to make double the minimum wage. Well, what's the minimum wage? It is not, thank God, the $17.75 or $29.90 or whatever that some of the local cities have. It is the state minimum wage. So currently, though, in order, if you have more than 25 employees, and you want to have somebody exempt from overtime, like a manager or a supervisor, they have to make a minimum of $62,400 a year. So that's 15 times 2 times 40 times 52. If you have less than 25 employees, it's 58,000 and change. So it's a big, hefty chunk of change. But if you're not satisfying the duties test, what that really means is that's how much you're going to owe them per hour in penalties and interest. So my suggestion would just be pay everybody their hourly rate plus overtime.
And that's really what I think the state is going to, because a lot of what we don't have time to discuss is very specific. You know, the duties are very specific. So, okay, so minimum wage is going up. Exempt people have to basically be maintained. So what does that do to everybody else? Wage compression?
Wage compression, isn't that an interesting word? Yeah, or phrase. Yes, what's happening is that as minimum wage has been going up over the last 4 years, especially in the local cities. Backtrack. I have to make one more point.
Go ahead.
Remote employees. If those remote employees are working in LA, living in Santa Monica, living in LA, living in San Francisco, this is very important. You must pay that minimum wage to those remote employees. That's a very important point because a lot of people forget that, and we get questions about that all the time. So going back to wage compression, as we've been increasing our minimum wage over the past 4 years, regular wages are really remaining stagnant. Non-minimum wage earners have remained stagnant. Now, since COVID, we've seen some increases happening, but wage compression is just basically meaning that now that a small business has to pay $15 an hour to its employees, it's going to raise its cost of a cheeseburger to $20, and people that are earning $80, $90, or $100,000 may or may not have as much disposable income left in their monthly budget to go out for that $20 cheeseburger because their wages have not increased congruent with minimum wage.
Right. So it really looks like it's a good thing for the economy to have that minimum wage raise. But as you've explained it, it's not across the board. The benefit is not across the board. It's only to a specific group of people.
And it might actually hurt small business economy because they kind of thrive on middle-class families going out on a Friday night for a cheeseburger.
Right.
But if it's going to cost $150 instead of $80, they may not be able to do that.
Right.
Well, the wage compression thing also is creating trouble in the workplace, if I could phrase it that way. Because if you're in a business where everybody's making minimum wage, well, somebody that got hired 2 years ago that maybe has just got bumped to $14 an hour, well, now everybody that's getting hired is getting hired in at the same rate they are. Because employers aren't taking into account
Right.
stepping everybody up
Right.
as the wage increases. They're just saying, okay, now we got to pay this for minimum, not thinking about where their current employees are. And that's something employers need to look at.
Right. And by the way, the answer is not having a policy that says don't talk about money with your coworkers, because let's just be honest, everybody's talking about that.
That's also completely illegal.
Yeah.
You cannot restrict an employee from talking about their wages or what their raise was or what their bonus was or anything else. And a lot of my clients want to try to restrict that type of speech. 100% illegal under the I'm going to get that wrong. FLSA. See, Fair Labor Standards Act.
So let's talk about 2022. We have new minimum wage. One of the things that I came across because it happened last year, but it became effective this year, is females in the boardrooms, meaning that females, if you have a board, you now have to have a certain number of ladies, or at least one lady in there, so that you meet that requirement. So those are just kind of like the oddball laws that we may have kind of forgotten about, but they passed last year and become effective this year.
Right.
I want to talk a little bit more about this year's. Which one's the one law that you think we should talk about because it's going to be the talk of the town?
Okay, I don't know if it's the talk of the town, but it's the talk of my office.
Oh,
or I
awesome.
don't know, or it's the one that's a little bit, I guess, concerning to
Okay.
me. And that's I love their fancy names for their laws, by the way. The Silenced No More Act.
Oh, yes.
So,
I like that one.
yeah. So back in 2018 BC, right? Again, that's my new term, is we passed a law that said in settlement agreements and in severance agreements, we would no longer allow confidentiality provisions for individuals who made claims of sexual harassment.
Right.
That was bad enough, in my opinion, because it stopped a lot of our negotiation tactics and prevented us from settling the way that I think that we should have been able to settle agreements before then. Well, now we have a new law that says not only can you prevent confidentiality provisions, you can't do a confidentiality provision for claims based on sexual harassment, but all forms of harassment and discrimination. So there's nothing left. I mean, when that's the heart of my litigation, is doing individual plaintiff claims. And what do they complain about? Discrimination and harassment and wrongful termination. So I go to a mediation, negotiate with their plaintiff, with their counsel. We come up with an agreement. Here's this much money. I'm going to give it to you. In exchange, I want you to go away, stop talking about it, and don't say anything bad about me or my client ever again. Can't do that anymore. That's basically the gist of this law, is that not only am I going to pay you money for saying things that I don't think are true, and mind you, if you look at the law, it says it prevents plaintiffs from, we can't prevent plaintiffs from stating factual information. What factual information? It is just what the plaintiff says is true. There's been no test. We haven't gone to a jury. This is about settling and resolving disputes. So the truth, factual, I just hate that word, shouldn't come into this at all. But now it means that we have to pay you money, and we can't prevent you from saying bad stuff about us or bringing up the facts. So
they're really silencing the employer.
I guess that's a good...
So it's silence no more from the employee, but we're going to silence the employer.
But the whole point of negotiation and settlement is for both parties to walk away not feeling good. But really what this sounds like to me is, why would an employer even want to give you any money at this point? I feel like maybe every case should just go to trial, but I know that's not going to happen. It just feels a little bit more like extortion.
Oh, yes.
More so than normal, because at least usually we could buy my client peace of mind.
Right.
He or she's going to go away. He or she's not going to talk about it. You get to move on with your life. And now I can't even tell my client that I can buy them that peace of mind.
So this is when the employer is in litigation. What about those general releases that people often will give when people simply leave? I have plenty of clients that it's part of their termination or resignation process that everyone signs off on a general release. Is that affected?
Those are also affected. Those severance agreements are, in fact, same way. You cannot prevent them from saying bad things about you or commenting about racism or discrimination or harassment. And also, this is new to 2022, in those severance agreements, you now have to specifically let your employees know that they can seek out counsel from an attorney.
It's a whole new world.
But Santa Claus still exists.
Santa Claus
So
and the
does
Easter
the Easter Bunny. That's right.
What was that?
Right.
And the Easter Bunny.
Yeah.
We're going to go to another quick break again while we're in the middle. Fun with HR is brought to you by Atharva Workforce. You can reach them at 805-826-0033. If you think hiring a professional is expensive, wait until you hire an amateur.
If you don't have an illness and injury prevention program, COVID prevention program, safety program, or emergency action plan, you could have Cal OSHA knocking on your door with a notice of violation and fines. If you need help creating these programs or help refreshing your existing program, contact the HR firm. They can walk you through the safety maze to get your company compliant while helping you keep your employees safe. They even do in-house training. They offer a complimentary 1-hour consultation for new clients. Check them out on Facebook or Instagram, or email them at info@thehrfirm.com. The HR Firm. If you have employees, you have issues.
Mortgage, a crazy method to borrow money. Do you know Bob Davis? He's been in Ventura County since 1967, in the loan business since 1985. Loan Depot and Bob Davis teamed up to provide honest and fair mortgage lending for everyone. Call 805-658-7435. Loan Depot and Bob Davis, real, honest, and fair mortgage lending. Call 805-658-7435. NMLS 249185.
You're not so typical nail studio. There's a revolution happening in nail care, and you're invited to join in when you visit the Ventura Harbor Village. Just walk into Frenchie's Modern Nail Care Studio and you'll know you're in for something that's beyond your typical medi-pedi experience. Call us at 805-200-3883 or email us at venturaca@frenchiesnails.com to book your next experience.
Finding people to add to your team can be difficult when you don't know where to start. Do you even have a job description? Do you know how much you should be paying them? Do you even know where to find the right people for your team? Let the professionals at Atharva Workforce help you get started and find your next star employee. Spend time on your business, not searching for that new star employee. Call Atharva Workforce at 805-826-0033.
Welcome back to Fun with HR. The Tharva Workforce is currently looking for window washing technicians, bookkeepers, back office dental assistants, sales associates, and jewelry associates. If this is you, contact the Tharva Workforce at 805-826-0033. I think we wanted to come back to talk about AB 1003, right?
Yes, wage theft.
Awesome. But not from the employee standpoint.
No. So when you say the employee standpoint, wage theft from the employee standpoint is oftentimes when you clock in and you're not working, but the employer is basically paying you. That's not what we're talking about. What we're talking about is definitely different. It basically says that it is a felony if an employer intentionally fails to pay wages in the amount greater than $950 to one employee, or $2,350 in aggregate to two or more employees within a 12-month period. Wow, that was a lot of info.
Yeah.
So break it down for us, Marie.
Okay, first break it down. This is just another way for plaintiffs' attorneys to bring class action lawsuits and add another claim into their civil action for penalties. Because what happens if you, again, I love the words. So it is wage theft is now considered grand theft under the California Penal Code. And the penalty is $200 per employee per pay period that they were underpaid, which again, it's just sort of like the PAGA Act. I'm using words that probably some people don't know, but it just adds to the value of a class action claim. Now, when I say I love words, it says the intentional deprivation of wages. So that would seem, well, intentional means you have to know you're doing it. Like I offered Rosandra $20 an hour. I'm only going to pay her $18 an hour. That would be your version and my version of the word intent. Even though it says intent, the word intent in the California Labor Code means I offered Rosandra $20 an hour. I accidentally paid her $18 and didn't do an audit to make sure that I didn't miss out that $2. That was an intentional act because I wrote her a check for $18 an hour. So intent really doesn't mean anything in this law, and I want to be clear about that. It's one of those very frustrating aspects of the way that laws are written.
What came to my mind the first time I heard about this law, and what's frightening is employers facing not only fines, but they're facing a felony charge, which is that's just like, if that doesn't make you frightened, then I don't know. But what came to my mind when I first heard about this law is, and we hear this over and over again when we meet new clients, oh, we don't pay overtime here. That would be intentional, right?
That would be intentional, and you actually have clients that say that?
Yes.
Okay, see, I almost lost my voice.
They're after they're our clients, they are paying overtime. But when we first meet them, they go, oh, we don't pay overtime here.
Yeah.
Oh, yes, you will pay overtime if you're going to be our client.
Okay. Like I guess nothing should surprise me anymore.
It's frightening how many times we hear that.
No. The other part about this is when the employer will often say, well, isn't it up to the employee to prove that I did this on purpose?
Oh, I just settled a class action at mediation on Tuesday of this week for well into the 6 figures, or 7 figures, unfortunately. And we had to go to a meeting with a bunch of people to see if this is going to actually go through. And a couple of people at that meeting, again, said, well, why is this our responsibility? It should be our employees' responsibility. And I had to explain that California, the burden is on the employer to audit those records and make sure that everything is right. So, I know we're talking about new laws, not new cases, but the issue really that's taking over class action litigation is rounding of lunch breaks. So
that was going to be our next thing. So that's a great segue.
Okay. Look, we're like reading each other's minds now. It's a little scary, but
those radio transmitters you have in the kiosks.
Al should be really, really afraid at this point.
Do you want me to talk about that now then? Oh, okay.
Yeah,
so
absolutely.
Another what a lot of employers do for ease is round time, clock in and clock out punches, and also for ease round the lunch breaks. And we've been reminding our clients for decades basically that it feels like that anyway. Yeah. You want to make sure that you keep accurate records because the burden's on you to prove that somebody took a break. Well, what if you've got people out in the field and they're just punching in or writing in their own time or entering in their own time later? So they work an 8-hour shift and then they enter in their time an hour and a half after they're actually supposed to be clocked out. That's technically not an accurate time record. So these new cases have essentially said, if you have perfect time records, that's a rebuttable position that you are violating California law and that you are in fact rounding and are liable for the penalties.
Which, again, it's the reason why I always tell my clients whenever they show me a paper time card, and it's always they start at 8 o'clock and you say 8 down the line, and they take their lunch at 12 o'clock and it's 12, and then it's 12:30. It's just too perfect. It just doesn't happen like that.
It doesn't. And again, I don't have a problem with that. Like, it's the real world, right? Everybody gets to work a few minutes early, a few minutes late. They probably take their break at 11:35 or 11:37, and they may come back at 12:22 or whatever it is. It's not going to be absolutely perfect. And it shouldn't be it seems burdensome, right, to track that perfect time. But unfortunately, our Supreme Court has said that, in fact, that's what you need to do. You have to make sure that time is accurately recorded, because when it's perfect, it means that you're doing something wrong.
Right.
And it requires a lot of interviews, a lot of deposition testimony, a lot of litigation fees to say that, in fact, you did everything right.
Right. And that's also the reason why I always tell my clients, because cost is always an issue. They seem to think that they need to have long, a lot of high-tech stuff, or basically they need to spend a lot of money on making this right. And there are very good options out there. You just have to make sure that you find one that meets your needs. And you definitely need to investigate this, because not doing something is not going to be a good defense. Again, ignorance is not a defense. And I'm not an attorney, but I know plenty of people that have told me that it's not a defense. So again, let's just find something that is out there that is going to work for you, that is going to meet the requirements of the law.
And also, it's a lot more expensive to litigate than it is to spend the extra money on the pay timekeeping procedures that are going to protect you.
Oh, goodness, goodness. So do we have any good news for employers in 2022?
Do we ever with these laws?
Yes, yes. I think this is a great time to talk about, some of the things that people may not know went into effect. So, for example, this is not HR related, but I think it's awesome. Dog blood donations went into effect in 2022. There's other laws, like I said, that went into effect. HR as a whole, with employment, what you're going to find is that they tweak the laws as things become known. So it's not like you're going to have whole new laws. You're just going to have amendments to existing or possibly new variations of it. So I want people to go to Marie's law update and really think of it as it's good news. It's not all bad news. It's good news. And the good news is she's there to help you. We're here to help you. The good news is that you're not at it alone anymore. Prior to Fun with HR, you may have never heard of the HR firm, but of course I know if you're in Ventura, we were it. But the other part is that's the good news. So that's what I was alluding to. You have resources. Having said that, tell me about when you're having this new law update.
We'll be recording it actually and doing it via Zoom in the next couple of weeks. We haven't actually set a date, and we're going to attach it, and this is what's most important. We're going to attach it to our LinkedIn website. That's Landegger, Verano, and Davis on LinkedIn. And there'll be a link attached to our Facebook website as well. So we're going to be doing these sometimes 5-minute, 10-minute, 15-minute updates throughout the year. And like I said, they'll be recorded, and you could just have easy access to the PowerPoints and the recordings so that you can use them whenever you want.
I really appreciate that because I have to tell you, we do go to plenty of law updates and they have beautiful PowerPoints, but very rarely do they make the handouts available after the fact. And I want to take notes. I want to be able to maybe know what questions I'm going to ask, and it's always wonderful to know that you're accessible. However, there is a limit. You do not represent employees, you represent employers.
Correct.
So if people need to get a hold of you, it would be employers.
Only. It is all that we do. It's all the firm has ever done. It's all the firm, as long as I'm there, will ever do is represent businesses. We have a soft spot for small businesses and nonprofits, especially. We'll take anyone, clearly. And I want to help employers because, as you can see, employers, the deck is stacked against them in so many ways.
It is
every year. And I've been working with Al my entire career, and I just could never go to the other side. So we strictly represent businesses and employers.
Tell us where you have offices.
We have one in Camarillo, right where the IRS building is. So I don't know.
How convenient.
How convenient. Pay your taxes. Come on up and see me. And then we have an office in Encino as well. That's where our main office is.
Yeah, go ahead.
I have a question about unused vacation and unused sick pay.
Okay.
So let's say somebody's in a position where if they are ill, the workplace just doesn't operate without them. And it can happen. So they tend not to use their sick leave because they know it's better to tuck in and be sick at work and get work done because it won't be a good thing when they come back. It would still double and triple their work, so they can't use their sick leave. And that also happens with vacation. They know if I go on and use my 3 weeks that I'm allowed, it's just going to be, it won't be a good place when I come back to it. So what is is it just tough luck or is it?
Okay, so first, when it comes to vacation, you can book it for as much as your employer will allow you to. So if the employer says you get up to 240 hours and then you stop accruing, then you have to take it. Otherwise, you're really missing out on an important benefit. Sick time is a little bit different. So the state gives you 3 days of paid sick leave. Most of these counties, like, again, Santa Monica,
Per
LA,
year,
per year, yeah. LA, San Francisco, Santa Monica give you 6 days of paid sick leave. that can be completely wasted at the end of the year. The employer is allowed to take that away. The employer has to pay you your unused vacation when you quit or are fired. The employer does not have to pay your sick time if you quit or are fired. So this is what the question we really get all the time is, I'm sick, but I don't want to use my sick pay because they want to wait and use it in December. Unfortunately, that's okay. You can't force them to use their sick pay because it belongs to the employee. This is just the standard. If you want to talk about how disability works and family leave and all that, that's a whole nother conversation. But if just the basic sick pay, it belongs to the employee, and the employee doesn't have to use it. So I could take an unpaid day off and be sick, and you can't do anything about it.
None.
Yeah. Did that answer your question?
Yes.
I think.
Yeah,
Okay.
it
I was
did, yeah.
I was trying to read between the
I've
lines.
never, for example, I've never used a sick day here. And I've worked here 30 years.
Right.
And we've had other people that used a lot of sick days. So.
And yeah.
That's what you're going to find in the workforce. You have some people that will use their benefits as soon as they become available, and others that will hold on to them for a rainy day.
In the interview, when a new employee comes in, and I just say, well, as a hiring person, how are you at using sick days? Like, are you a tough guy? Are
No,
you
that is not an
not
okay
even.
question.
No.
Is there any way on a workaround?
No.
I love your idea, Tom, from earlier this morning. Tom had this amazing advice suggestion to do interviews from now on like The Voice. And so that all interviews should take place.
Nobody sees anybody
Nobody
or
sees
anything. And when they flip around, you go, "You're my hire,"
That's it.
and it could be literally anyone.
We're going to see how that works. We're going to suggest that to a Tharva workforce and see what they say. We'll let you know next week.
Oh boy. It's just going to be great. But it is, for some people, it's funny because, and what you said is so perfect, because if, let's say, I get, and this company's very generous with its sick pay. It's very generous. And, so it's good. I think they're very fair here. But then, like you're saying, like, I'm not sick, even though I am sick, and then in December, I'm sick. And so I benefit myself by using those almost as vacation days, going to maybe Thanksgiving, my birthday, and I could just conveniently, and they call them personal days somehow. Is there a difference legally
There's
between?
difference, yeah.
Okay.
It's sick time. That's why we always say, make your sick time, vacation time, vacation time. I'm sorry, do that again. And then the last thing is PTO. You could do PTO, which lumps together personal time and vacation time and can include sick time. But we don't want that to happen. We want sick time to be separate because that's the only stuff that you don't have to pay out. If you lump it into PTO or vacation, you got to pay it out.
So if you're asking somebody in an interview, how do you legally ask somebody how often they miss work?
You can't.
You not at all. You
No,
cannot.
it's a question you can't ask.
You can't.
We'll give you a list of questions
That
you
I can't ask.
Yes.
I better have them.
Or you might need Rosandra there on
Exactly,
your next interview.
and again, this is why HR firms are important.
Yeah.
Because I would think it'd be tough like me, a wimp. Come on.
We've had clients that have gotten in trouble because that's exactly what they vocalize to their employees and their candidates. And so we've had to let them know, look, we want you to just stay with these questions, and we provide the questions, and then we provide the process so that we stay away from you needing somebody like Marie. So again, Marie and I work together, just so everyone knows. Human resources does not fear attorneys and whatnot. We need to work together because in essence, I do all the groundwork, the boots on the ground, so that if something goes really sideways, Marie doesn't have to do that work. It's already done, and I just hand over all my files over to somebody like Marie, and it should be properly documented and everything is ready to go. So it actually ends up saving people money to use human resources correctly, and then, they can avoid litigation. There's no guarantees, but you could try and avoid it. And then the other part is, after everything is said and done, then Maria and I would work together to see, okay, these are the policies we need to change. This is how we need to modify so that we could avoid this from happening again in the future. So it's actually a working relationship. I love my attorneys, and I love them because we need to corroborate, and we need to help grow the community together. So please don't think of it as it's an adversarial relationship. It's quite the opposite. I love, like I said, my attorneys, and that's how I think employers should approach HR and their attorneys. It's not one is better than the other. It's just better to have them both work together.
Am I permitted to record interviews,
No.
No.
even if I tell them?
No.
I just wouldn't suggest it. That's all. Even if you tell them, because again, if you tell them, they're going to say, "Oh, I only said yes because I wanted the job,
Right.
and I felt pressure."
So let me tell you, I had an opportunity to interview a few years ago for a job that I now realize I never wanted. And what they did is they said, "We have so many candidates coming through our doors. I need to take your picture." And I thought, what the heck? But the way they asked to take my picture, I had to decline. They wanted me to take off my jacket, and they wanted me to pose. They wanted to pose me.
What kind of place did you go to?
Exactly. It was in Ojai, so I was kind of lenient.
Oh.
But at the same
Ojai.
time, I thought, no, can't do this. And by the way, I said, I need to talk to your HR person. So we'll have to talk to you, Tom. about
Yes,
how
I
you-
need to have people in, I guess, in office when I'm hiring.
Okay. It's happened again.
It has happened again.
Oh my goodness. So one of the things I wanted to say is thank you everybody for listening. Don't forget to look at our website and our Facebook page for Marie's information. Thank you, Marie, for joining us.
This was fun. Thank you.
You should come back more often.
We should have Marie back in more often because we didn't even touch half of the stuff that
We
we
should-
prepared.
We should. I'm now part of the we. Just so you know, is that maybe we could come back and do like a question and answer. Can
Absolutely.
people call in or anything like that? That would be fun.
Absolutely. We can
Yeah.
do all of that. Go ahead, Jeff.
Okay, I'm there.
Go for it.
Fun with HR was brought to you by the professionals at the HR firm and the Tharva workforce. We care about each other. We take care of each other so that we can grow together. Until next week, we all wish you a happy week, and we'll see you again next week. Thank you.
I'm out of time and all I got is 4 minutes. 4 minutes, eh? I'm out of time and all I got is 4 minutes. 4 minutes, eh? I'm out of time and all I got is 4 minutes. 4 minutes, eh? I'm out of time and all I got is 4 minutes.